Listen carefully, my friend, because if you've ever had a loan, a credit card, a mortgage, or even an old financing agreement that you already finished paying, what I'm about to share could completely change the way you see your debts. Thousands of Americans over 50 are still sending money every month for hidden charges, abusive interest rates, and mysterious fees quietly slipped into contracts, and most of them don't even realize it. The truth is that every time you borrow money in the United States, whether from Bank of America, Wells Fargo, Capital One, or another lender, the law requires that you receive clear and transparent information about the money you borrowed. The interest rate applied, and every single fee included, like late charges, payment protection insurance you never asked for, processing costs, or penalties disguised with complicated names. But banks and collectors make it hard, filling contracts with fine print and endless jargon so that you'll feel overwhelmed and just keep paying. What most people don't know is that there's a powerful tool called the Debt Validation Letter, and under the Fair Debt Collection Practices Act, you have the right to demand this document and force the creditor to show you everything, the original amount borrowed, the total interest charged, every payment you've already made, and any extra costs they've slipped in along the way. It's like turning on the light in a dark room, suddenly exposing what was hidden. But here's the catch. No bank or collector will ever give you this letter unless you ask for it, and if you don't, you'll never know if the balance they're demanding is inflated or even legal. That's why millions of Americans feel trapped, embarrassed, and exhausted, stuck in payments they shouldn't even be making, thinking they have no choice when in fact the law is on their side. And in this video, I'm going to show you step-by-step how to request your debt validation letter, how to file a complaint with the CFPB if the bank refuses, and how to finally understand what you really owe. But what I'm about to reveal next is even more important and will surprise you even more. Now let me explain why this debt validation letter is such a game changer, because most people don't really understand what happens inside their debt. They just see a monthly bill with a number that keeps going up and feel powerless. Imagine this. You took out a personal loan for $10,000. You've already been paying for years, and yet when you check your balance, it feels like it never goes down, almost as if the money you send each month disappears into thin air. That's because a huge part of what you pay isn't even reducing your principal. It's going straight into interest, fees, and sometimes even insurance policies you never asked for. Banks and collectors rely on the fact that most people over 50 don't want to fight. They're tired. They feel ashamed of having debt, and they trust whatever statement comes in the mail. But once you request a debt validation letter, suddenly the game flips, because the lender is legally required to show in writing the exact breakdown, original loan amount, interest rate, APR, all the late fees or penalties they've added, and the payments you've already made. For the first time, you can look at your debt and understand where every single dollar has gone. And here's where it gets even more interesting. If the collector or the bank cannot provide this information, or if they make mistakes, you can dispute the debt, freeze collections, and even force them to remove it from your credit report. That's right, the FDCPA and the Fair Credit Reporting Act protect you against abusive practices, but the law only works if you know how to use it. And believe me, banks hope you'll never take this step, because once you do, their entire system of hidden charges and confusing contracts begins to crumble.
It's like suddenly having a flashlight in a dark cave where they've been hiding the truth for years. But I'm not stopping here, because in the next part I'm going to show you how to actually write and send this letter the right way, so it cannot be ignored, and trust me, this is the moment when many people finally start taking control back from the banks.
So let's get practical, because knowing your rights is one thing, but putting them into action is what really changes the game. Writing a debt validation letter might sound complicated, but it's actually simple if you know what to include, and here's where most people mess up. They send vague complaints or emotional messages, and the collectors just ignore them. What you need is a clear, firm, and legally based request. Start by writing your full name, address, and the account number they're trying to collect from you. Then use strong but polite language, something like, I am requesting validation of this debt under the Fair Debt Collection Practices Act. Please provide the original contract, a detailed breakdown of the balance, including principal, interest, fees, and any insurance or charges applied, and a record of all payments made to date. This makes it crystal clear that you know your rights and you're not going to be pushed around. You should also demand they state who the original creditor was, because in many cases, debt is sold from one company to another, and by the time it reaches you, the paperwork is full of errors. If they can't prove the chain of ownership or if the numbers don't add up, they cannot legally continue to harass you. Once you've written the letter, don't just send it by email or regular mail. That's another mistake. You have to send it certified mail with return receipt requested, so you have legal proof that they received it and the countdown begins. By law, once they get your request, they must pause all collection efforts until they provide the documents you asked for. That means no more phone calls, no more letters, no more threats, nothing, until they validate the debt properly. Can you see how powerful this is? For the first time, you're no longer the one running scared. They are the ones who have to prove themselves. But hold on, because in the next part, I'm going to show you what to do if they ignore your letter or try to trick you with incomplete information, and that's where things get even more interesting. Now, let's talk about the part that really scares the banks and collectors. What happens if they ignore your letter, delay their response, or try to send you something incomplete hoping you'll just give up? This is where most people make a huge mistake because they think, well, I tried, they didn't answer, so I guess I have to keep paying. No, absolutely not. The law is very clear. Under the Fair Debt Collection Practices Act, once you've asked for validation, they are legally required to stop all collection activity until they provide full documentation. That means they cannot call you, they cannot send threatening letters, and they cannot report new negative marks on your credit. If they do any of that, they're violating federal law and you can actually sue them for damages. But collectors are clever. They might send you a generic statement with a balance and call it proof, or they'll mail you a copy of your last bill and claim that's enough. Don't fall for that. Validation means they must show the original agreement, the exact terms, the interest rates applied, all fees added, and the history of payments. If they fail to do this, you're not just free to ignore them, you actually gain leverage. You can file a complaint with the Consumer Financial Protection Bureau, CFPB, and trust me, when a federal agency gets involved, banks start paying attention. You can also send a dispute to the credit bureaus, Equifax, Experian, and TransUnion so that any inaccurate information is removed from your report. Imagine how powerful it feels to see that debt erased from your credit file simply because they couldn't prove it was valid. And here's the bombshell. Many collection agencies don't even have the paperwork anymore because debts are sold and resold so many times that the trail gets lost. Which means the moment you demand proof, their case collapses. But wait until you hear what I'm about to reveal next, because if they refuse to validate your debt, you may not only stop paying, but also have the chance to recover money you already sent them. Here's the shocking part most people have never heard before. If a collector cannot validate your debt, not only can they be forced to stop chasing you, but in some cases, you can even get back money you already paid. Think about that for a second. You've been sending hundreds, maybe thousands of dollars over the years, feeling trapped, ashamed, and exhausted, and then you discover the company never had the legal right to collect from you in the first place. Under federal law, if they violated your rights by continuing to call after your request, by reporting false information to credit bureaus, or by charging fees they can't justify, you may be entitled to damages. Some people have taken collectors to court and walked away with settlements that not only erase their debt, but also put money back in their pocket. Now, I'm not saying this happens every time, but the possibility alone should make you realize how much power you actually have when you use the law correctly. And here's the thing. The Fair Debt Collection Practices Act wasn't designed for lawyers or financial experts. It was created for regular people like you, especially older Americans who are often targeted by aggressive collectors. If you know how to write a proper letter, keep records, and file complaints with the right agencies, you can protect yourself and sometimes even turn the tables completely. Imagine the relief of not only stopping the harassing phone calls, but also seeing a check arrive in the mail because they broke the law. That's the kind of justice people rarely talk about, and it's why understanding these steps is so important. But here's something even more critical you need to know. There are strict timelines, and if you miss them, you lose many of these protections. So in the next part, I'll explain the deadlines you must follow so your rights don't expire without you realizing it. Now we need to talk about something that can make or break your entire strategy: deadlines. The law gives you powerful rights, but those rights come with a clock that starts ticking the moment the collector first contacts you. Under the FDCPA, you have 30 days from the date you receive a collection notice to send your debt validation letter. If you send it within those 30 days, the collector must pause everything until they provide proper proof. But if you wait too long, they can keep collecting without being forced to stop, and you lose one of your strongest protections. That's why timing is everything. Don't let fear or confusion cause you to delay, because every day that passes puts you in a weaker position. And here's another important detail. Even if you miss the initial 30-day window, you can still dispute inaccurate information directly with the credit bureaus under the Fair Credit Reporting Act. So never think it's too late. You just need to know which door is still open for you. The truth is, banks and collectors are counting on you not knowing these rules, because ignorance is their biggest weapon. But now that you understand the timeline, you can flip the script and use it against them. And if this information is opening your eyes and helping you see that you don't have to be a victim anymore, then take a second right now to subscribe to this channel, because here we talk about the things nobody else dares to say, in simple words, with real examples, so you can finally defend yourself. Go ahead and click that button, because what I'm about to explain next will show you exactly how to use official government tools in the United States to file complaints that force banks to answer, and this is where things get really powerful. This is where everything comes together, because once you understand your rights and the timelines, the next step is using the most powerful weapon available to regular Americans, the Consumer Financial Protection Bureau, or CFPB. This is a federal agency created after the 2008 financial crisis, and its only mission is to protect people like you from abusive banks, shady lenders, and ruthless debt collectors. And here's the secret hardly anyone knows. When you file a complaint with the CFPB, the bank or collector is legally required to respond within a set time frame, usually 15 days, and they have to provide a real explanation, not just excuses. It doesn't matter if it's Bank of America, Wells Fargo, Chase, Capital One, or a small collection agency. When the CFPB gets involved, they all take it seriously because they know the government is watching. Filing a complaint is simple. You just go to consumerfinance.gov/complaint, log in with a basic account, and fill out a short form. You explain the problem, upload your debt validation letter, attach your contract if you have it, and press submit. That's it. The CFPB takes your complaint, forwards it directly to the company, and forces them to give you answers. For many people, this is the first time they finally see a breakdown of their debts, the hidden fees, and even admissions of mistakes. Some people even get refunds after filing. Imagine how it feels when the same bank that ignored your calls suddenly sends you a letter apologizing and fixing your account because the CFPB told them to. That's the kind of power you hold in your hands when you know where to turn. And the best part is that this process is completely free, so you don't need a lawyer or expensive legal advice to use it. But here's the twist. While the CFPB is incredibly powerful, most people never use it, and in the next part, I'm going to explain why that happens and how banks manipulate your fear to keep you from ever filing that complaint. Now let's uncover the psychological game that banks and collectors play, because it's not just about numbers on a statement, it's about fear and shame. Think about how many times you've received a collection call and felt your stomach drop, your heart race, and your hands sweat. They use aggressive language on purpose, saying things like, "You're running out of time," or "This will destroy your credit," because they know fear makes people act without thinking. For older Americans, especially those over 50 who already feel vulnerable, that fear is multiplied. Collectors also count on shame, making you feel embarrassed for having debt, as if you've failed at life, so that you'll avoid telling anyone and never seek help. And here's the cruel trick. They rely on that silence to keep you from filing complaints with the CFPB or disputing errors with credit bureaus. They know that once you shine a light on their practices, they're exposed, so they do everything possible to keep you in the dark. That's why understanding your rights isn't enough. You need to break free from the fear and recognize that having debt doesn't make you weak or worthless. Debt is a business, and banks profit from keeping you confused and ashamed. But once you realize that the law is on your side and that you have official tools to fight back, the fear begins to fade and the balance of power shifts. Imagine how different your life would feel if the next time a collector called, instead of panicking, you calmly said, "I already sent my debt validation letter. You cannot contact me again until you prove this debt." That simple sentence flips the entire conversation. And believe me, when you use those words, the silence on the other end of the line will shock you. But this is only the beginning, because in the next part, I'm going to reveal how to use your credit reports themselves as a weapon, and this is something that can change your financial future forever. One of the most overlooked weapons you already have in your hands is your own credit report, and if you're over 50, chances are you've never really looked at it closely because it seems confusing and intimidating. But let me tell you something that could blow your mind. Your credit report is not just a score. It's a record that companies use against you, and you can turn it into a shield if you know how. In the United States, there are 3 major credit bureaus: Equifax, Experian, and TransUnion, and by law you are entitled to a free copy of your report from each of them every year through annualcreditreport.com. Most people never check, and that's exactly what collectors want, because those reports often contain mistakes, duplicate debts, inflated balances, or accounts that don't even belong to you. Once you have your reports in hand, you can go line by line and compare what the collector says you owe with what's actually listed. If you spot an error, even something small like the wrong balance or an unfamiliar account number, you have the right to file a dispute directly with the credit bureau. And here's the secret. Once you file that dispute, the bureau must investigate, and the collector or bank has 30 days to prove the information is correct. If they can't, the negative mark must be removed. That means your credit score can jump up just because they failed to provide documentation. Imagine how powerful that is, turning their laziness or sloppy record-keeping into your victory. This is why so many people who take control of their reports suddenly feel lighter, freer, because they see black and white evidence that the debt is either invalid or overstated. And don't forget, removing negative marks doesn't just help your pride, it saves you money by lowering your interest rates in the future. But here's where it gets even more interesting. There are certain words and phrases you must use when disputing errors to make sure the bureaus take you seriously. And in the next part, I'm going to reveal exactly how to phrase your disputes so they carry maximum legal weight. Now let's get into the exact words you should use when disputing errors on your credit report, because this is where most people fail without realizing it. If you just write something vague like, "This account doesn't look right," or "I don't think I owe this," the credit bureau might mark your dispute as frivolous and toss it aside. You need to be specific, clear, and use language that forces them to investigate. For example, you can write, "I am disputing this debt because the balance listed is inaccurate. Under the Fair Credit Reporting Act, I request that you provide documentation showing the original contract, the payment history, and any fees applied." That phrase alone, referencing the Fair Credit Reporting Act, signals to them that you know your rights. Another strong example: "I do not recognize this account, and I request validation of ownership and supporting documents." Or, if you see the same debt listed twice, you can write, "This account is duplicated, which creates an inaccurate representation of my credit, and I request immediate removal of the duplicate entry." See how powerful these sentences are? They're simple, but they leave no wiggle room. Once you phrase your dispute this way, the credit bureau has 30 days to investigate, and the collector must provide proof. If they can't, the negative mark disappears. Imagine the relief of watching a debt vanish from your report just because you used the right words. And here's another secret. Always send your disputes in writing by certified mail with return receipt requested. Emails and online forms are easy to ignore, but a letter they have to sign creates a legal record they can't escape. This is how you transform a simple piece of paper into a weapon that can clean your credit and protect your future. But here's the kicker. Even when you do everything right, some collectors will still try to pressure you with settlement offers that sound tempting, but are actually traps, and in the next part, I'll reveal why those offers can end up costing you more than the debt itself. Now let's talk about one of the sneakiest tricks collectors use: settlement offers that look like a lifeline but can actually trap you even deeper. You've probably seen or heard it before: "We'll let you settle this debt for half the balance if you pay today." At first, it sounds like a blessing, right? Who wouldn't want to cut their debt in half? But here's the ugly truth. When you accept a settlement, you may be admitting that the debt is valid, even if it wasn't, and that can prevent you from disputing it later. On top of that, the amount they forgive doesn't just disappear. In many cases, the IRS treats canceled debt as taxable income, which means the following year you could get a 1099, see form in the mail, and owe taxes on thousands of dollars you never even had in your pocket. Imagine thinking you escaped your debt only to be hit with a surprise tax bill that destroys your budget. Collectors know most people over 50 don't realize this, and they use your desperation to push you into quick settlements that benefit them more than you. Another danger is that some companies offer payment plans on settlements, but don't put the terms in writing, and after you send money, they claim you defaulted and demand the full balance again. That's why you should never agree to a settlement without understanding the legal and financial consequences. Sometimes fighting for validation and disputing errors gives you a much cleaner, safer outcome than rushing into what looks like an easy deal. The bottom line is this: if a settlement sounds too good to be true, it probably is. But don't worry, because in the next part I'm going to reveal the safe and legal ways you can negotiate debt without falling into traps, and how to use the law to make sure any deal you accept actually sticks. So, how can you negotiate debt in a way that protects you instead of trapping you? The first rule is simple: never do it over the phone without getting everything in writing. Collectors are trained to sound friendly, even sympathetic, but once you hang up, their promises vanish into thin air. If you're going to negotiate, demand a written agreement that clearly states the amount you will pay, the fact that the debt will be considered settled in full, and that they will report it to the credit bureaus as paid in full or settled. Without that paper in your hand, you have nothing. The second rule is to use leverage. Remember, most collection agencies buy debt for pennies on the dollar, sometimes just 5 or 10 cents for every dollar owed. That means if you owe $5,000, they may have paid only $500 for it, which gives you room to negotiate from a position of strength. You can offer a lump sum, maybe 20 or 30% of the balance, in exchange for full closure, but again, it must be documented. And here's another trick: when you send the payment, use a cashier's check or money order from a separate account. Never give them direct access to your main bank account. Too many people hand over debit card information and suddenly see extra charges they never authorized. Protect yourself at every step. And finally, don't be afraid to walk away. If the deal doesn't meet your terms, you're not obligated to accept it, especially if they can't validate the debt properly. Negotiation is not about begging, it's about control, and the law gives you the right to demand fairness. Imagine the relief of knowing you settled a debt for a fraction of the cost, legally, with no hidden strings attached, and having the paperwork to prove it. But even that is only part of the story, because in the next section I'll reveal how you can use state laws, not just federal ones, to give yourself even more protection depending on where you live, and this is something almost nobody talks about. Most people think the only protection they have comes from federal laws like the FDCPA or the Fair Credit Reporting Act, but the truth is every state has its own laws that can give you even more power if you know how to use them. For example, some states like California, New York, and Texas have stronger rules that limit the amount of interest a creditor can charge, or that give you the right to record collection calls as evidence. Other states have shorter statutes of limitations, which means if a debt is too old, the collector can't legally sue you to recover it. Imagine owing money from 10 or 15 years ago, only to find out the law in your state says they can no longer drag you into court for it. That's information that can change your life overnight. Some states also have consumer protection divisions within their attorney general's office where you can file complaints, and trust me, when a collector gets a letter from the attorney general instead of just from you, they start shaking. The key is to check your state's rules, because what's allowed in Florida may not be the same as what's allowed in Illinois. And here's something else collectors don't want you to know. If they try to sue you in the wrong state or after the statute of limitations has expired, you can have the case thrown out completely. Imagine walking into court scared and leaving with the case dismissed because the collector didn't follow the law. That's why it's so important to not only understand the federal protections, but also to look into the specific laws where you live. Knowledge is leverage, and the more leverage you have, the harder it is for them to bully you. But we're not done yet, because in the next part I'm going to explain how debt consolidation and credit counseling companies often pretend to help, but can leave you worse off than before. And you need to hear this before you even think about signing up with one of them. Let's clear up another big trap that many people fall into when they're desperate: debt consolidation and so-called credit counseling companies. On the surface, they look like saviors, promising to combine all your debts into one simple payment or to negotiate with your creditors on your behalf. But here's the harsh reality. Many of these companies charge high fees up front, and while you think they're paying your creditors, sometimes they're just collecting your money for months before they even send a single payment. Meanwhile, your accounts go past due, your credit score crashes, and the collectors come after you even harder. Some programs also require you to stop paying your debts while they negotiate, which triggers lawsuits, late fees, and interest that keeps piling up. And don't be fooled by the term nonprofit either, because many credit counseling agencies still make their money from the banks, not from truly helping you. I've spoken to people who signed up thinking they were on the road to freedom, only to discover they owed even more after a year in the program. The truth is, the tools I've been sharing with you, debt validation letters, disputes with credit bureaus, complaints with the CFPB, are often far more effective and completely free. You don't need a middleman draining your wallet while pretending to be your ally. If you ever consider debt consolidation, you must read the fine print carefully, check reviews with the Better Business Bureau, and make sure the company is accredited by the National Foundation for Credit Counseling. But even then, approach with extreme caution, because once you sign those contracts, it can be hard to get out. And this brings us to the final piece of the puzzle, because in the next part, I'll show you how to put everything we've covered together into a clear, step-by-step plan that you can follow starting today to finally take back control of your financial life. So now you've seen the full picture, and maybe for the first time in years you realize that you're not powerless, you're not stuck, and you're definitely not alone. The banks and collectors want you to believe that debt is a prison with no escape, but the truth is you have keys in your hands. The debt validation letter that forces them to show the real numbers. The Fair Debt Collection Practices Act that makes them stop harassment. The credit reports you can use as weapons to erase inaccurate information. The CFPB complaint system that obligates banks to answer. The state laws that can shut down lawsuits. And the knowledge to avoid traps like fake settlements and shady debt consolidation companies. All of these tools exist for you, not for the collectors, and once you put them into action step by step, you flip the power dynamic completely. Imagine how your life changes when the phone stops ringing with threats, when letters from collectors turn into apologies, when your credit score begins to climb, and when you finally sleep at night without that heavy weight on your chest. That is not a dream. It's what happens when you educate yourself and fight back with the law on your side. And listen, if this video gave you clarity, if it opened your eyes and gave you the confidence to stand up for yourself, then don't keep it to yourself. Leave a comment below with your name and where you're watching from, because I want to know your story. Share this video with friends and family who are struggling, because this information is public, it's free, and it can change lives. And of course, subscribe to this channel so you never miss the truth that no one else dares to explain. I'm not here as a lawyer or a doctor. I'm here as a men's financial health specialist who has seen too many people suffer in silence, and I refuse to let you be the next victim.